Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. Today, we've brought together a number of our hosts to recount and reflect on the best of our Curious Amalgam 2021. We'll find out what made these episodes memorable and which of our guest predictions have come true since we posted their episode. This is Christina Ma, and joining me today are Alicia Downey, Matthew Hall, Melissa Maxman, Kayla Odom, and Anora Wang. Welcome, everyone.
Hi, Christina.
Hi, Christina.
We're so happy to have everyone together. So I'm going to start with Alicia. Tell us a little bit about what we're doing and launch us into our first best of 2021.
Well, thanks, Christina. As our Curious Amalgam has now rounded its second anniversary, I thought it would be fun for those of us who are regular hosts to think about what were our favorite episodes of 2021 and present some excerpts. The first one I want to turn to is Matthew Hall. And Matthew chose a sports-themed episode that first appeared June 14th, 2021. I'll turn it over to Matthew to introduce the episode and talk a little bit about his guest. I do want to point out, though, that when I selected clips from these favorite episodes, this was the one where I left Matthew's question in because I just thought it was amusing just by itself. So anyway, without further ado, Matthew, tell us a little bit about this episode.
Hi, Alicia and everybody. Thanks for inviting me on. Yes, this episode was about the proposed Super League football or soccer breakaway competition in Europe. I like this episode because the issue is so high profile. It's, of course, the world's biggest sport. And an example of when competition or antitrust law became really part of the mainstream. It was all over the traditional press, at least here in the UK and in Europe. And even the UK Prime Minister, Mr. Johnson, accused the breakaway clubs of forming a cartel. Just to remind ourselves of exactly what happened here in April 2021, 12 leading clubs announced a breakaway league. This was on a Sunday, for some reason. There was a massive backlash from fans. Mr. Johnson made his statement. UEFA, the European League organizing body, issued a famous statement on the same day saying that the clubs will be banned from playing in any other competition and the players will be banned from representing their national teams. So there were competition or antitrust issues flying around from that first day on the Sunday. We spoke with Dwayne Bach, who's the sports and esports law expert and author on the subject about the competition law implications and the future of the whole saga.
What do you think about the future, both generally in terms of breakaway leagues, or are we just going to have to wait for the European Court to give its view on that? Do you think things are going to happen again? And also, what about the Super League itself? You know, you mentioned there are 3 clubs remaining. Why? It seems that there's nothing. They're not going to play each other every week, presumably. Even that would get a bit boring. But so what's going on there?
So to your first question, I think there will be no attempt to establish such a league in the near future because the reactions by fans and the media was just too negative. Maybe in the long term, in 10 or 15 years, we'll see another attempt because you can't forget that European football is just really attractive for foreign investors, but that would be an issue in the long term. And regarding your second question, the media speculates that the reason behind the clubs, the 3 clubs that are still in the Super League, could be money, because the contract every Super League club had to sign includes a clause that provides for a compensation that has to be paid by every club that leaves the league. But I think what's really interesting right now from a competition law perspective is that case that you name. So the judge in Madrid submitted several questions to the European Court of Justice in the context of Article 267 TFEU. And there the judge asks, for example, if the planned measures by the UEFA and the federations and Article 49 UEFA statutes that I named before violate competition law. So, as you said, it's a very important competition law case that's on the horizon right now.
Matthew, you mentioned that this was a cartel, probably the shortest lived cartel, if it was a cartel, announced on a Sunday. How long did the Super League last?
It lasted, at least this iteration of it, lasted about a day or two before 9 of the clubs, under the pressure of prime ministers and fans, dropped out. However, as Dwayne pointed out, the three clubs are still pushing on. And that case he mentioned was very interesting, that they went to a Madrid court to get a stay or an injunction against UEFA, which had issued that statement about banning them. And that case is still rumbling on. It's been through some iterations in the Madrid court, and it's now ended up in the European Court of Justice in Luxembourg. In September, they published the questions, which are all around, as we said, Article 101 and 102, so far as they impact the actions of UEFA, whether it's basically abusing its dominant position under 102 by trying to impose these measures and exclusions on the clubs, and 101, whether it's acting as a cartel itself. So that's where it's got to, still rumbling on, but a very interesting case.
Thanks, Matthew. For those listening, if you want to hear the whole episode, it was episode number 119. We always have a question in our title. This one started with, is this game over? Competition law implications of the Super League. I think the game is over, don't you think, Matthew?
The Super League is definitely over for now. But the game in court is certainly not over. That's going to be rumbling on for some time.
Great.
Matthew, a personal question for you. Are you a football player, and who's your favorite team?
I play casually. My favorite team is Watford, which is a UK team. I was born in Watford, so overlooking the Watford Vicarage Road ground. So that's my rationale for that.
Right. Go Watford. Turning now to our next regular host, Kayla Odom will talk about why she selected episode 104, Have We Figured It Out? Online Privacy and Security in the New Normal of Video Conferencing.
Hi, Alicia. Hi, everybody. Yeah, so this episode aired back in March 2021, which was about the 1-year mark after the pandemic began. And so by that time, people were definitely familiar with video conferencing. I'm sure we all were. It having been implemented in so many different aspects of our lives, from work, school, healthcare, you name it. And so Christina and we spoke with Claudia Rast and David Turetsky, both cybersecurity and privacy experts. And in the episode, we discussed the various online security and privacy challenges we as a society had to face due to the pandemic-induced Zoom boom. So from like early issues of uninvited cyber attackers showing up in your Zoom meeting, which I think might be resolved by now, but also transparency from the companies running the video platforms and having them correct misleading misrepresentations regarding privacy and security, even leading to an FTC investigation of Zoom. And so one of the last questions I asked Claudia and David was, what was their number one prediction for the biggest issue we might have to confront and need to look out for when it comes to privacy and security of video conferencing?
So one thing that is sort of out there lurking that we haven't seen a lot yet, but those in the cybersecurity space have been aware of for maybe 2 years now. And all these video meetings have made data rich, would be deep fakes. That's something that we have to be really concerned about in the future, because we are all now on video. How many Zoom calls do we have a day? I mean, what is the opportunity to grab a snippet of that video and then attribute it to somebody else in a deep fake kind of way. We have our audio recordings, so the voices are there that can be, the manipulation opportunities are tremendous.
Wow. I'm not sure if we've seen any major deep fake stories in the mainstream news lately. And that could be due to the fact that deep fake detection technology is improving, or people are just becoming more aware of the issue. I don't know. What do you guys think?
I think deepfakes are terrifying, right? The thought of someone creating a video of yourself and it not being you. And I was, when the audio was playing, I Googled, how to detect a deepfake, and it's just like, pay attention to the face, pay attention to the cheeks, pay attention to the eyes. It's like, does anything seem off? And even though detection is getting better, I wonder if whether the manipulations themselves are also getting better.
That's certainly true. And, I think governments, businesses, and just people in general, we're all going to have to sort of train ourselves on being able to know what's real and what's fake. We already have issues with that when it comes to things that are written in the media and put online. But when it's a video and it's someone you're talking to, for example, like say you get a video call from a name you recognize, and then that person's voice and 3D image shows up on the call, but it's manipulated and you have no idea. I don't know if we'll ever get to that place, but I think Claudia was foreshadowing that could be a possibility. Cyber criminals they're developing new methods, and we just got to stay on top of it. So I guess we'll see what happens in that space. Here's what David said.
I guess because I use Zoom for teaching, and some professors use other tools, I do think that who has access and whether and how long any of the Zoom meetings may last unexpectedly is really the biggest worry I have, that there'll be some sort of discovery, and it may be that it's a participant in the meeting, recording something and doing something with it. It may be that they don't even know that they're recording their screen in some way, that they have some sort of software on it, and maybe it's malware, maybe it's a third party doing it. But I do worry that our expectations of who we're talking to, whether or not that conversation lasts, and who has access to it, will, for one reason or another, prove false, and that we'll be surprised at that.
Yeah, so David brought up a good point. We're always focused on external people coming in, but we might be surprised from the inside. People who have access to the recordings, people who we're talking to, and there's always the risk that they could do something without our permission or without us knowing. People can surreptitiously record a phone call, so what's stopping them from doing that with a video call other than the law? But I think when it comes to organizations, that means it might be up to the individual organization or the host to decide best practices and policies that they would want to share with their members, and perhaps implementing training for video conferencing. I'm not sure if any of you have experienced that in your workplace, but I think that's an important issue to look out for as well.
I think it'd be interesting to know whether there could be a technological approach to that, a button, for example, that I as the user could push that would prevent a video conference from being recorded. So I could affirmatively not consent and flip a switch to make sure that could not happen. I don't know if that security feature exists, but I can't think of a reason why it wouldn't.
My only response is that someone could just pick up their phone and record the conference using, that device, or at least the audio.
Right.
So I don't know if there's a way to fully prevent someone from recording if they really wanted to, other than everybody putting it out there that, hey, I don't want this recorded.
Right. Well, good scary thoughts from those guests. Thanks, Kayla. Turning to Anora Wang, who presented an episode with which which might be the one with the longest title. This one came out. It was episode number 128. When will it be the end of global anti-suit injunction wars? Present and prospective FRAND litigation and arbitration in China. This was a very interesting episode. If you haven't heard it before, I really recommend going back and giving it a listen. But Anora, what highlights are you going to present today?
Sure. I actually have two clips. Oh, and hi, everyone. I have two clips from this episode I would like to share with the audience, and I think they're among my favorites. It's always hard to pick favorites. Alicia, you mentioned that this might be the one episode with the longest title. You might appreciate the fact that we already have an acronym in the title. Otherwise, it would be even longer. So the main reason I picked this episode is because I'm just simply so proud that we were able to do something that's so specialized and technical in a lively and interesting conversation of 20 to 30 minutes. And you highly recommend I do the same. I think people, if you're a really interesting friend, which is really a specialized area in IP and antitrust, and you're interested also in development outside of the U.S., this perhaps you might, we've got a gem for you. And the guest we had for this episode is Jing He, who's a leading Chinese practitioner with decades of experience in intellectual property, antitrust, and complex litigation. And he was able to, in this first clip, to explain to us what FRAND litigation is like in China and how it differed from development elsewhere.
Judge Burrs in the United Kingdom issued the ruling on the global FRAND rate in a patent infringement case. He basically was telling Huawei, the Chinese company, to say, hey, I'm going to issue the injunction, but at the same time, I'm also determining the rate. If you pay the rates, you're not going to subject to the injunction. So that's how it happens. But in China, we twist it. What happened is not patent owners go to the court, right? Normally, you got to be patent owners filing the infringement lawsuit. The court have a chance to determine the damages and then the relevant to the rate. Now, in China, our companies go to the court to say, hey, because the patent owner has a FRAND obligation, it's more like a contractual obligation. So I'm asking the court to determine a rate for us. Obviously, people worry that, hey, Chinese court have this, Chinese implementer have this home court advantage. That's what's all this about.
So I will give you my thought when I actually first heard from Jing explaining this. I think it's obviously in a lively conversation like this, everything is a little bit overly simplified. But I think the approach that he's taken and just making a contrast, like, what motivates different parties to go to court and what motivates their essentially their demands, right, and requests from the court, is very interesting. And by looking at country by country and what are the main groups of of the litigators, it's really interesting perspective. And in a second clip of this episode, I also asked Jane to read tea leaves and predict what will happen in the IP and antitrust world generally.
There are probably still some brave parties still gonna rely on the court litigations, but I'm predicting that people probably gonna really get more mature in a way that all the frustration out of the ASIs will probably have people make some more of a bold judgment. They're probably gonna look in some more alternative way to resolve the disputes.
Yeah, I think what was, interesting about both of Jing's points is just the degree to which, there's forum shopping globally and trying to identify the most favorable place. And I think the backdrop of looking forward is whether some of the political tensions we're seeing between, the U.S. and China and other countries may cause private practitioners to look for these alternative forums that are not necessarily, in the court system that may be subject to influence.
That was going to be my reaction is, what if the same company is litigating on a same or similar patent in one jurisdiction, like in the UK, and then also in China? How might that affect their business strategies and people who use similar technology? Like, is everybody going to be keeping an eye out for where these cases are brought?
Yeah, that's exactly one of the hard questions in front, right? How can one court, which is sitting in one jurisdiction, determine a global rate? But there was more in our conversation with Hejing. So if you want to learn more, definitely go back to episode 128. And we actually, this is one of three. We actually had a series on France. So if you're interested, you might want to also check out the two preceding to this one.
Thank you very much, Anora. Turning now to something slightly different. Back in the United States, Melissa Maxman selected episode number 134 as her favorite. The title of that was, What Does It All Mean? Wu, Con, Counter, and Antitrust Reform. This was posted September 27th, 2021, not so long ago, but certainly as the Biden administration has selected its appointees for the FTC and DOJ Antitrust Division, a very timely one. So Melissa, tell us about this episode and the very special guest who spoke.
Thanks, Alicia. This is a personal favorite of mine because in large part of the guest. It was Bill Kovacic. He is now a professor of antitrust law and policy, and he's the director of the Competition Law Center at George Washington University Law School. Among other things, he was a FTC commissioner in the early aughts and was chaired the agency from 2008 to 2009. And he was general counsel there. I mean, he knows the FTC back and forth. He also happens to be just a very charismatic speaker. He uses vibrant adjectives to describe things and wonderful metaphors and anecdotes. And so I had prepared basically to talk to him about what do you think is coming. Jonathan Kanter had just been announced as the nominee for the head of the AAG for the Department of Justice for antitrust. He had not been confirmed yet. As a matter of fact, he was just confirmed a couple of weeks in late November. And the thing about Bill is on almost any topic that has historical significance and also has current significance on today's antitrust policy, he's just off. You just ask him a question and he waxes lyrical, and it's just a delight to hear.
Imagine Chair Khan, as a law student 5 years ago, being asked by a recruiter, what do you plan to do in 5 years? And she said, I plan to be the chair of the Federal Trade Commission. I think the recruiter would have said, we're finished, and good luck in your delusional career. That's never going to happen.
So I was laughing out loud. Luckily, I was muted as he was saying this. And that was in response to my question about the future of the FTC. What did he think was going to happen? And how was Lina Khan, how did the Biden administration come to appoint her? And how did he think she was going to do? Now, he went on to say very, very nice things about Chair Khan. But for those of you who don't know, for one thing, she's my daughter's age. She's 32. Second of all, she's about 5 years out of law school, and she had a piece published in the Yale Law Journal, which is where she went to law school, called Amazon's Antitrust Paradox, which was taking off on Robert Bork's antitrust paradox. And it's not really a response to it so much as a modernization. Those of us who are old enough to remember when Robert Bork wrote the antitrust paradox and read it in law school, which was 40 years ago, well, we're going to come to another clip that Bill talks about, but he really changed the face of antitrust. Robert Bork did back in the 80s. And I think we're seeing the pendulum swing back, both philosophically and, quite frankly, politically. Bill was picking up on the fact that there's this very young, very intelligent, very well-spoken, and outspoken female head of the FTC who's really shaking things up.
And I would just add that there's a phenomenal, well, maybe people wouldn't describe it as phenomenal, but there is a November New Yorker article profiling Lina Khan for those that haven't seen it, and we can link to it to this episode, but certainly talks about her experience and what has led her to becoming the chairwoman of the FTC. And it it was to her just as much of a surprise as it was, I think, to the rest of the world. So,
and she's been controversial, but even Kovacic, who's clearly a Republican, is willing to give her the benefit of the doubt.
Today, they've changed the conversation. That is, we are talking about issues as mainstream concerns that have not received this kind of prominence going back to the 1970s, where the broader egalitarian vision of antitrust law disappears in Supreme Court decisions, roughly from Brunswick in 1977, Sylvania in 1977 onward. They brought that back into clear relief. So the whole conversation about the field has changed.
And I think that's what Bill was referring to. If you listen to the rest of the podcast, we got into a discussion about the Borkian view of antitrust, which the antitrust paradox picked up on, and basically said the antitrust is there to protect big business from getting too big. That was the Brandeisian view. If big business got too big, and this was the problem with Standard Oil back in the 40s when they enacted it, the danger was it would take over the government. And then Bork started writing about the fact in the 80s that really shouldn't be the focus. What should really be the focus is consumer benefit and how to get better prices and more products and more choice to consumers. And this has been seen as the Borkian approach. What you're seeing with Kahn, what you're seeing with Cantor, and I think it's in response to a number of things, both big tech, which is everybody's whipping boy right now, but also medical healthcare regulation. People are getting worried about how big things are.
He said egalitarian. I just wanted to highlight that word. It really makes you think. Like, if that's where we are today, is that how we think about antitrust laws today? Egalitarian.
I don't know. I don't think any of us know. I think what we're seeing a lot of in the agencies is a move towards making sure that businesses have a level playing field more than to make sure that consumers get lower prices. Because the way to get consumers lower prices is to allow Amazon to basically control everything, and Walmart and whatever, and there will be very, very few players in the marketplace. There'll be less innovation. It'll be harder to break in, but the volumes create discounts that get more stuff to people. On the other hand, is that necessarily a good thing for U.S. society? I think it was a very elegant way for him to say that.
That's great, Melissa. Thanks so much. And last but not least is me. My favorite episode of 2021 was number 135, and the title of it was, Is Equality a Value of Competition Law? A conversation with Professor Eleanor Fox. Now, what was fascinating to me was just to listen to the perspective that she had, over about the changing landscape of antitrust law here in the United States.
I've been practicing antitrust law in the United States since 1961. And I knew very well in the 1960s period, which was the Warren Court period, that antitrust was naturally sympathetic to a better distribution of wealth and income to those who were on the outside, not the inside. And I also knew and lived through the great antitrust revolution of the Reagan era and the judges Reagan appointed and the new acceptance of the Chicago School, that all of that was overturned and antitrust became a vehicle for efficiency. That was a real revolution. Since the 1980s, it's been cold antitrust rather than hot antitrust.
I should put that comment into context. The topic of the episode was an article that Professor Fox co-authored about sort of the role of what she called an equality value in antitrust and antitrust legal standards, and specifically equality as it relates to wealth and income. It's something like what the sort of the current people who are interested in antitrust reform are considering. But what her article did was really put it all into historical context and talk about the fact that, at least as she sees it, There was an equality value built into antitrust analysis in the early days of antitrust. That changed. And it may be that there's a way to open the door to reconsider issues like equality going forward. The other thing I asked Professor Fox about was what she would recommend at this point for the future of antitrust in the U.S.
One of my recommendations is to say that we really ought to pay attention to who wins and who loses. And that if the poorer population are constantly the losers, maybe something is wrong with the law. A related recommendation is to say that the way we have been doing economics is using Calder-Hicks, which is if the winners win more than the losers lose, that's efficient and you shouldn't touch it. And I am saying that it would be a really good idea to disaggregate, say you're using consumer welfare standard, to disaggregate who are the consumers. If the rich consumers are always winning by having a rule that companies can have resale price maintenance, but poor consumers are always losing, that ought to be relevant.
So I would not call Professor Fox a radical. I wouldn't, but I think that, an opinion like hers coming from somebody with such longevity should carry some special weight. What do others think?
Interesting comments there, Alicia. I haven't seen it put that way, at least in the EU, but it has kind of reflections of the fairness doctrine, possibly. The fairness doctrine was a bit trendy, I guess, a few years ago. Question was, is competition law to do with fairness as well? And that was looked at in terms of, I guess, the kind of pure procedural issues, but also what it should be aimed at more generally. But I never saw it extended to those comments by Professor Fox, aimed at, if you like, making it fair at the very level of the individual consumer in terms of spreading the ensuring income equality. So I thought that was an interesting further extension of that concept.
I wonder if Professor Fox's prediction that the pendulum might be switching back to a focus on equality, if that's where we're headed. I mean, I think this is definitely something that everybody's thinking about, and to focus on who loses disputes. I thought that was a great way to put it. One way to think about, what reform might be needed.
We've spent much of the year talking about antitrust reform and the need to reform the consumer welfare, the perception that the consumer welfare standard needs to be reformed. It's not clear that there is a unified view on what we should focus on. Does antitrust policy need to focus on improving democracy, on privacy, on equality? And I think the verdict may still be out on what it should be, if not consumer welfare.
And people want different things, don't they? Some people want it to cover climate change and sustainability. Some people want it to cover equality. Some people want it to cover consumer welfare. I guess it can't do everything.
Well, that's great. Thank you to everybody. If anybody in the audience wants to hear these favorites and other great episodes in their entirety, all of the episodes are available on the OurCuriousAmalgam.com website and wherever you get your podcasts.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at OurCuriousAmalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@OurCuriousAmalgam.com. Until next time, thank you for listening.